This is the time set for possible changes of plea and status conference state versus Michael Crane, CR 2012-007950, CR 2016-000999. Appearances, please.
Good morning, I'm Patricia Stevens and Julie Wazinski appearing on behalf of the state. They're also members of the Shapiro and Gaudet family on the telephone conference line.
Good morning.
Good morning, Your Honor. Eric Aiken for Rebecca Motlaw in the 176 matter.
Good morning.
Good morning, Your Honor. Jamie Starks and Herman Avendar on behalf of Mr. Crane, who is present and in custody.
Michael Crane on behalf of Michael Crane.
Good morning. Mr. Crane, it's my understanding that you wish to change your plea in the 7950 case to count 1 burglary with 2 prior felonies, class 3 non-dangerous repetitive offense committed November 30th, 2011, between November 30th, 2011 and December 5th, 2011. Count 2 theft with 2 prior felonies, a class 4 non-dangerous repetitive offense committed December 6, 2011. Count 3 misconduct on weapons with 2 prior felonies, a class 4 non-dangerous repetitive offense committed December 6, 2011. Is that correct?
Correct.
Do you understand that if you plead guilty, you subject yourself to a mandatory prison sentence for each of those 3 counts? Do you understand that, sir? No. It's a repetitive offense. The law would mandate that you get a prison term that's presumed to be 11 1/4 years on the burglary count, 10 years on the theft and the weapons charge. Under the law, it could go up to 25 years in the burglary case, 15 years on the theft and the weapons charge.
I understand what you're saying, but I don't understand how this works, but go on.
Well, I need to make sure that you know what you're doing and you understand what you're doing and you want to do what you're doing. So what questions do you have?
What difference does it matter if I plead guilty, if I say I take the responsibility for all these charges and you guys have a trial? What difference does it make if I do this now or later?
Well, I don't know what later is. Today relates to 2 cases.
Do you understand what I'm saying to you, though?
Well, I don't. You know better than I do what later means.
I really don't.
Well, no one can force you to change your plea, Mr. Crane. Right now, the options are going to be a plea or a trial in 3 cases.
I've already told you that I'm willing to accept responsibility for all these charges. So that is what I'm telling you right now.
Well, and I'm answering in that, in order for me to accept that choice by you, I have to make sure that you understand the ramifications of that choice. And among the ramifications,
I understand the ramifications that you're telling me, but I don't agree with them.
Well,
that's what I'm here on special visitation only. You need to remember that.
well,
Rights are reserved under UCC 1-308. You need to remember that.
and we've talked about that too, but I have to take baby steps to go through this, Mr. Crane, and if you can't follow me, then we won't do it.
Here, may I have just one moment?
Yes?
I don't think you understand either. Listen. Oh, excuse me. Okay. I mean, trial or not, there's nothing. It doesn't matter. We're going to go to trial. We're going to sit here. We're going to say nothing at all. I don't even want you guys representing me in the first place. Do you know that? My position stands firm on this. There's nothing to say, period. let's go ahead and go through these proceedings, but just understand that one way or another, this is, you're forcing me in the contract by keeping me in a jail cell, by keeping me confined. Well, like I told you, I'm accepting responsibility for these charges. I don't agree with your commercial ruling fraud that you commit every day in this court. I don't know what else to do. I don't know what to do.
Well, you and I are going to engage in a conversation, and we'll see where we are at the end of it.
Let's go with that.
You understand that by pleading guilty, you are going to be facing mandatory prison for each of these 3 counts.
I understand that's what you're telling me.
The presumed sentence for the burglary charge is 11.25 years. It could legally go down to 7.5 years. It could legally go up to 25 years. You understand that?
I understand that.
With respect to the theft and the weapons charge, the presumed sentence is 10 years. It legally go down to 6 years, and it could legally up to 15 years. Do you understand that?
I understand, but I don't agree with that.
It would be lawful to run these concurrent with each other. It would be lawful to run these stacked on top of each other. Do you understand that?
I understand that, but I don't agree with that.
Each one of these would be an 85% count. Do you understand that?
I understand that, but I don't agree with that.
In the 999 case, it's my understanding that you are intending to plead guilty to count 1 burglary with 2 prior felonies, a class 3 non-dangerous repetitive offense committed between January 31, 2009 and February 12, 2009. Count 2 burglary with 2 prior felonies, a class 3 non-dangerous repetitive offense committed between May 28, 2009 and June 3, 2009. Is that your understanding?
I understand it, but I don't agree with it.
Well, are you willing to do it?
What do you mean?
The fact that you don't agree could mean that
I don't agree with the laws I'm being charged. I've told you, I've already told you this already. I'll say it again. I accept the responsibility for the crimes that I'm being charged with.
By accepting responsibility, that means that you would be facing mandatory prison for both of these counts as well. Do you understand?
I understand that, but I don't agree with that.
The presumed term is 11.25 years. It could legally go down to 7.5 years. It could legally up to 25 years. Do you understand that?
I understand that, but I don't agree with that.
If you are sentenced, the sentences can run concurrent with each other, or they could be stacked on top of each other. Do you understand that?
I understand that, but I don't agree with that.
The sentences in this case could run concurrent with or be stacked on top of the other case. Do you understand that?
I do, but I don't agree with it.
Do you understand that if you plead guilty, you're giving up constitutional rights?
Which constitution are we talking about?
The right to remain silent.
Which constitution are we talking
The
about?
U.S. Constitution.
Which U.S. are we talking? Are we talking about the federal constitution of the District of Columbia, that U.S. Constitution, or are we talking about the states of the Union common law constitution? Which constitution are we talking about?
You'd be giving up your Fifth Amendment.
I'm asking a question. You're not answering my question. You're committing fraud by remaining silent on this issue. My question is real simple. You're asking me questions. I'm asking you questions. I'm not trying to be difficult. I want to get this over with. I've been here for almost 7 years. I'm asking you a simple question. Are we working under the common law, or are we using a federal constitution?
The federal constitution. And Mr. Crane, if you don't want to engage in the rules, then that's fine. We can proceed.
I don't agree with the rules. I don't have a choice either way. You are giving me no choice. You're forcing me to have counsel. You're forcing me to go to trial. I have no choice in any of these matters whatsoever. The only thing that I can do is protect myself the best that I can. Most of this stuff, I just have a basic comprehension of. So I ask you again, are we working under admiralty law, under statutory jurisdiction?
No.
We're not. Really? Okay. That's going in a lawsuit right there. You just committed fraud. Thank you very much again.
You're giving up your right to remain silent, your privilege against self-incrimination, your right to refuse to testify, right to plead not guilty. Do you understand that, sir?
I understand that, but that's not under the original Constitution, the original Bill of Rights.
You're giving up your right to a jury trial where you'd be represented by a lawyer. Do you understand that?
I understand that, but I don't agree with that.
You're giving up your right to cross-examine or question any witness the state called. Do you understand that?
I understand that, but I don't agree with that.
You're giving up your right to call witnesses, present evidence, and testify yourself if you wanted to. Do you
I
understand that?
understand that, but I don't agree with that.
You're giving up your right to have the jury determine your guilt beyond a reasonable doubt. Do you understand that?
Excellent. Yeah. I said excellent, but I don't agree with that.
You're giving up your right to have that jury determine any aggravating factors beyond a reasonable doubt. Do you understand that?
I understand it, but I don't agree with it.
You're giving up your right to file a direct appeal of your case. Instead, the way you appeal is to me. If I turn you down your claim, you can go to the appeals court, but they won't have to take your case. Do you understand all of
They
that?
don't have to take my case anyway. They're just as corrupt as you.
Knowing that you're giving up all of these rights by entering into these plea agreements, this change of plea, is that what you want to do?
I don't have much of a choice here.
Yeah, you have an absolute
I
choice.
really don't. I really, really don't.
Your choice is to go to trial, or your choice is to plead. That's up to you.
One way or the other, I'm telling you, I did everything that you're telling me I did. It's going to happen in trial here, so yes, I agree.
Have you had enough time to think about this?
I'd say plenty of it.
Has anybody forced you to make this decision?
Absolutely.
What has forced you to make this decision?
Let's see, 7 years in confinement in 4th Avenue Jail. You guys not answering my questions. You giving me no choice. You forcing me to have counsel. You not allowing me to represent myself in a pro per status or proper sui juris status by you not answering my questions, by the state not answering my questions.
Has anybody threatened you to make this decision?
Absolutely.
How so?
Every single time that I'm either forced to come to this courtroom, which I am here under duress and under threat with my life, or further imprisonment in the 4th Avenue Jail, absolutely. What do you mean? What kind of question is that? Serious?
Are you asking that I accept your plea?
Absolutely. What are you asking me? What are you saying to me right now? I don't understand what you're saying.
You want me to accept your plea of guilty?
Do you want to accept my plea?
I'm not at issue here, Mr. Crane. The only issue today is whether you are entering a change of plea that's knowing, intelligent, and voluntary, and whether this is something that you know what you're doing and you want to do it.
One way or the other. Let's be straight up here. Like I said, I'm not an attorney. These guys won't answer my questions. You won't answer my questions. The state won't answer my questions. So let's just say this. I will say yes under the presumption that that you understand and know that I am here under duress. I am here under special visitation. I'm not accepting your laws one way or the other. Okay. And that I'm reserving my right to the Uniform Commercial Code, UCC 1-308, UCC 1-103.
Is it okay that I accept your changes of plea, Mr. Crane?
Under the terms and conditions that I just stated, only, without prejudice.
Is it true in between November 30th, 2011 and December 5th, 2011, you went on the premises of someone who lived on Broomfield without their permission?
Correct.
And you took property that was not yours to take,
Correct.
and you were armed at the time.
Correct.
And among the things that you took was a motorcycle,
Correct.
and you would agree that the value of that motorcycle was between $3,000 and $4,000,
Yes, correct.
and that you took a rifle.
A rifle?
Yes.
When did that happen?
A,
Yes, so yeah, let's say, why not?
a J.C. Higgins rifle. He just had it.
Correct, I guess. Go ahead. Doesn't matter at this point. Go ahead, correct.
I can't let you plead it. There's not a crime, Mr. Crane.
Your Honor, regarding the factual basis on the misconduct involving weapons, that was actually at another location, his grandmother's house, where there was a J.C. Higgins rifle that was found. That's separate and at a different location from the Bloomfield
Let's
address.
make it not separate. Just go ahead and
No,
add it to the,
well, is it true, Mr. Crane, on December 6th you had possession of a rifle?
sure, why not?
And I know prior pleadings that you have filed, you think it's unconstitutional, but you would concede that you did not have your rights restored when you had the rifle.
I've never had my rights taken away. If you look at any of those contracts I signed, my rights were reserved to Uniform Commercial Code 1-207 at the time and 1-103. I never gave up my rights.
I understand that, but you never got them restored either.
They were never taken away. It was an unclosed deal. It was an unclosed matter. Can't take away my rights, period, anyways. My rights are inalienable, sir. Now, if we're talking about the federal Constitution and we're talking about the District of Columbia, certainly you could take away my rights. If you're calling me a person or a domicile or an agent that is a domicile in the District of Columbia, sure, you can take away my rights, but I am neither of those. I'm an American man born in the States of the Union.
Let me change the subject to get back to that weapons charge then. Is it true that back in 2010 you were convicted of the felony offense of possession of drug paraphernalia?
Yes,
And you had a lawyer that represented you in that case?
I did.
And in 2010 you were convicted of the crime, the felony of facilitation to promote prison contraband?
Correct.
You had a lawyer that represented you in that case?
Correct.
And then
Much younger and stupider version than me.
by reason of those convictions, you had lost your constitutional right.
I never gave them up.
Well, let me take these baby steps I told you, Mr.
Okay.
You had lost your right to possess a weapon had you gotten permission to get a weapon from DTS.
That's what the District of Columbia, that's what the sub-franchisee Arizona is saying. But you can't take away rights that are inalienable. I never signed them away. At the time that I did that, I reserved my rights to the Uniform Commercial Code, which reserves my rights to the common law. And in accordance with the common law, you can never take away my rights, period, ever. Check the files if you don't believe me. Go right on ahead. Every single document from that stage, from the signing process, reserved my rights to the common law.
That was one of the issues you raised earlier. I ruled earlier.
I don't even remember raising that issue earlier.
It is subject to review, I guess. So
I guess so.
the question I have for you is, did you get your rights restored by DPS after your felony
Rights
conviction?
restored, that's what I'm telling you.
I'm sorry?
I never had to get my rights restored, is what I'm telling you.
I understand what you're saying, but did you?
I'm telling you that I never had my rights taken away from me in the first place.
Okay. In the 999 case,
You
is
guys can
it,
say whatever you want to say. That's just some bullshit.
in the 999 case, is it true that between January 31, 2009 and February 12, 2009, you went into a residence on Lafayette Boulevard without permission
Correct,
for the purpose of taking stuff that was not yours?
correct,
And you were armed at the time?
correct.
Is it true that in that
Was I armed?
between May 28th, 2009 and June 3rd, 2009, you went to a residence on 35th Place
Correct,
without permission
correct,
and took property that was not yours to take?
absolutely,
You were armed at the time.
absolutely.
And in those instances, there was someone there with you.
No,
There was someone that got you there or helped get rid of the property.
no,
Ms. Stevens, is there a basis for the accomplice charge on either count 1 or count 2 in the 999 case?
Your Honor, in regard to the 999 case, the laboratory results show that a Brittany Beinhauer was present at the scene of the burglaries charged under that cause number.
For both of the places?
Count this one.
On one of them, Judge, if I may.
That would be count 2.
That's the, so someone else was with you at the 35th Avenue, 35th Place residence, Mr.?
what, give me the address, I can't, I
35th Place, it would, I don't know if you know the
Bust it
gentleman's name.
can't even remember I don't know what you're talking about. What's the place called, what's the address,
35th Place.
and what?
I don't know the answer to that, and I'll get it for you.
No,
That was in Phoenix, Your Honor, Maricopa County.
Say again?
That was in Phoenix, Maricopa County.
Right,
Say was or wasn't?
was.
Address on Cross Street.
No.
No. The first one was not the other side.
I can guarantee that. No. No, I have no idea what what we're talking about right now. I think, I'm being honest, you're dishonorable, Brando. You could believe that.
Cross Street.
I'm gonna say no regardless. I'm not a fucking rat.
Okay,
But no, honestly, I've never done anything with that woman.
Mr. Crane, is it true that in February of 2017,
Never even seen that place before.
Cross Street.
Nice house. Is that right?
That's what it was.
Mr. Crane?
Yeah.
Is it true that in February of 2017, you entered into a change of plea to count 4 aggravated assault, a class 3,
That's what it was.
dangerous with 2 prior felony, committed February 1st, 2012.
Yeah.
Count 5 armed robbery, a class 2 dangerous with 2 prior felonies, committed February 1, 2012. Is that true?
Correct.
Count 6 burglary, a class 2 dangerous felony with 2 prior felonies, committed February 1, 2012.
Correct.
Count 7 armed robbery, a class 2 dangerous with 2 prior felonies, committed February 1, 2012.
Correct.
Count 8 aggravated assault, a class 3 dangerous felony with 2 prior felonies, committed February 1, 2012. Count 9 attempted burglary with 2 prior felonies, a class 4 non-dangerous repetitive offense, committed February 1, 2012.
Correct.
I had found that those pleas were knowingly, intelligently, and voluntarily made and accepted the pleas. Is that also true?
No. Not in the way I reserve my rights to the uniform.
You did?
They were made without prejudice.
The same way
But
today,
in accordance with UCC 1-308.
you are going to seek to vacate everything that we've done. I understand that.
What do you mean?
You're going to appeal everything that we're doing.
I'm not going to appeal.
Well, then,
I don't even want to appeal.
well, then
There's nothing to appeal.
I go back to the fact that you're going to be sentenced to prison on all these counts then.
That's what you're telling me. I don't agree with it, but that's what you're telling me.
have you had
I'm not
any,
giving you permission to send me to prison. I'm not going to sign a contract that's going to send me to prison, not voluntarily.
have you had
But
any-
you have told me this. You said that you have the power to force me into signing a contract. I remember that. Do you remember saying that?
have you had any?
Do you remember saying that?
I don't remember telling you got to sign anything.
Do you remember when I asked you, if we go to trial and I lose trial, and I asked you this question specifically, my memory's working right now, that's awesome. And I asked you this question specifically. I said, do you or the state have the power to force me to sign a contract that's going to send me to prison? And you said yes. Am I
Yes.
correct about that?
He's talking, Your Honor, about at the end of either a plea where he signs his rights, whether it's through a trial or through
He knows
a
what I'm
plea.
talking about.
And
Well, your phrasing of a contract is, I don't accept that premise, but
Oh, excuse me, what does that mean? You say you don't accept that premise. You said those words to me personally. Did you not?
I would
Just,
not.
let me ask you the question again. Let me ask you this question again. if I go to trial right now and I lose and I'm found guilty of every single one of these charges, okay? Do you have the power? Are you saying that you have the authority to force me, a sovereign American man, not born in the States of the Union, force me into a contract, sign a contract that's going to send me to prison? Because this is what this comes down to at the end of the day.
It would not be a contract.
What are you speaking of?
I would order that you be remanded to custody of the Department of Corrections.
At the end of these proceedings, one way or the other, there's a contract that I sign that sends me to prison. You said that you had the power to force me to sign a contract. Are you going back on what you said?
You keep using the term contract. There's paperwork at the end to
Paperwork's contract, this is what, I mean, are we serious? Are we
get
being
a
serious right
fingerprint
now?
to make sure that we got the right guy.
Okay, so you have the power to force me to put my fingerprint on a document that you're saying is not a contract, not a commercial contract that involves color money and color law? Is that what you're telling me right now?
Yes.
Wow, okay. Thank you. That's all I wanted to hear.
Have you had any drugs,
Fraud.
alcohol, or medicine in the last 24 hours?
Absolutely not.
Has the jail prescribed you medicine that you've chosen not to take?
Absolutely.
When's the last time you had any medicine?
I can't remember.
The fact that you have not had prescribed medicine, do you think that affects your ability to understand what we're doing?
I doubt it.
Again, I'll ask Mr. Crane, are you asking that I accept your pleas today?
Only under my terms and conditions,
Which are?
that you accept and without prejudice in harmony with UCC 1-308 and UCC 1-103.
Okay.
Okay.
I understand what you're saying. I have to accept your plea under the Arizona Constitution, the U.S. Constitution, and Arizona statutes.
Which uses Uniform Commercial Code law.
Title 13.
Business transactions.
Title 13. Either counsel have any questions on the sufficiency of the factual basis for counts 1, 2, or 3 in the 950 case, counts 1 and 2 in the 999 case?
Judge, I don't have any question about the sufficiency of the factual basis. I think we have in this hearing and previous hearings covered the legal issue this defendant has with jurisdiction. I just wanted to add, because I'm not sure we covered it, that all of the counts that you mentioned were in the city of Phoenix and Maricopa. The state is in compliance with victims' rights, although this isn't a plea agreement, it's a plea straight to the court.
Mr. Crane, all of these locations you would concede were in Maricopa County.
Correct.
Counsel, anything on the sufficiency of the factual basis for any of the counts today?
Yes, Your Honor, I just wanted to correct the record as to count 1 on the, that is in the 7950 number. Even though Mr. Crane admitted that he was armed at the time, there was nothing to indicate in the discovery that we've reviewed to indicate that he was armed at that time as to count 1. Also, I just want to clarify that as to count 2 regarding the motorcycle, that was actually found at a different location, although it belonged to the owner of the resident on Bloomfield. And finally, the J.C. Higgins rifle was again at a different location. And finally, as to the 2 in the 09999 cause number, that was in Maricopa County. That was at a basically at a condominium type location, and the way Mr. Crane was connected to that location was they found his DNA on some beer bottles, and also the other co-defendant at that location. And again, that was within Maricopa County.
Thank you. Any council have any questions on the knowing, intelligent, or voluntary nature of Mr. Crane's plea to any of the charges?
I have nothing to add, Judge.
I'm sorry?
I have nothing to add.
Your Honor, yes, we would object. We do not believe that Mr. Crane's plea is knowingly, intelligently, or voluntarily made based on his responses today in court, based on my hour-and-a-half meeting with him last week in jail when discussing pleading guilty, based on my conversation with him yesterday, based on my interactions as discussed in the competency hearings, as discussed in Bishop's statements. For all of those reasons, we believe that this particular decision is the result of the mental disease or defect discussed in those competency hearings, and that he should not be allowed to plead guilty.
I disagree with what she's saying.
Ms. Stevens?
Judge, competency has been thoroughly litigated before this court and is not at issue. The state has no question at all about this defendant's competency. The state, as this court has previously explored, understands this defendant's disagreement with this court's jurisdiction under the sovereignty laws, and I believe we have, through all of the hearings, throughout all of these CR numbers, thoroughly covered that matter. We do not have a question about his voluntary knowing and acceptance of responsibility. It's very clear he accepts responsibility factually. His remaining objection is to this court's jurisdiction, and under the prior plea, under the 7950 case, he has litigated that matter, including taking a special action, and has been advised not only by this court, but the Court of Appeals, that this court does maintain jurisdiction over him.
Your Honor, I apologize just briefly for the record because competency is fluid. I just want to make sure that that includes a visit last week with him, which is after the finding of competency, and my interactions with him today in court and yesterday.
And except that the concept of competency is fluid, it's also such a threshold issue, it's jurisdictional, so folks beyond me don't think we did it right. There's an opportunity to fix it. But the ultimate question, Mr. Crane, right now the choice is limited. I will grant you that. It's a choice to trial or a choice for me to accept your plea. Given that choice, which would you prefer?
The choice to accept the plea only under my conditions.
The court does find that the plea in the 750 case to count one burglary with 2 prior felonies is a Class 3 non-dangerous repetitive offense committed November 30th, 2000, between November 30th, 2011 and December 5th, 2011. And count 2 theft with 2 prior felonies, a Class 4 non-dangerous repetitive offense committed December 6th, 2011. Count 3 misconduct in weapons with 2 prior felonies, a Class 4 non-dangerous repetitive offense committed December 6, 2011, is knowingly, intelligently, and voluntarily made. There was a factual basis to support each plea. In the 999 case, the court finds that for count 1 burglary with 2 prior felonies, a Class 3 non-dangerous repetitive offense committed between January 31 and February 12, 2009. Count 2 burglary with 2 prior felonies, a Class 3 non-dangerous repetitive offense committed between May 28th and June 3rd, 2009, are both knowingly, intelligently, and voluntarily made. There is a factual basis to support each plea. The court finds that Mr. Crane has suffered a felony conviction in the 2009 516 case, the possession of drug paraphernalia, a Class 6 non-dangerous, non-repetitive offense committed February 19, 2009, for which he was convicted in May 27, 2010. Mr. Crane has suffered a conviction in the 2010 case for facilitation to promote prison contraband, a Class 6 non-dangerous, non-repetitive offense committed September 6, 2009, for which he was convicted in May 27, 2010. And that on February 23rd of 2017, this court accepted pleas of guilty to count 4 aggravated assault, a Class 3 dangerous with 2 prior felony offense, 5 armed robbery, a Class 2 dangerous with 2 prior felony offense, count 6 burglary, a Class 2 dangerous with 2 prior felony offense, count 7 armed robbery, a Class 2 dangerous with 2 prior felony offense, count 8 aggravated assault, a Class 3 dangerous with 2 prior felony offense, Count 9, attempted burglary with 2 prior felonies, not as a Class 4 non-dangerous repetitive offense, all committed February 1, 2012, therefore subjecting Mr. Crane to a Category 3 sentence for all of the counts. There had been a sentencing pending in the 950 case, and there's now, the court will need to set sentencing for these 2 cases, so the parties have a date in mind.
Judge, it would seem to make sense to set this in early February on the capital case that remains. Defense counsel is submitting materials to the state, which we expect to receive, review, and have a response on hopefully by the end of January. So it makes sense to the state in regard to the 7950 and the 999 matters to set them for sentencing in early February, as well as a status on the capital case, the 176 matter.
You want me to order a pre-sentence report at this time?
Yes, please.
Alcantara, what's your position on a pre-sentence report at this time?
What's that? Yeah, the clerk can go ahead and order it, and also that we be notified so we can be present.
Right. We'll set a sentencing on a Friday in February. To the 176 case, we need to reset the current last day. If a trial is warranted, when would you have that trial from your end, Ms. Stevens?
The defense counsel has advised me that they would be requesting, I believe it was June. We do have a number of interviews to complete. I think there are approximately 90 to complete, though the major participant interviews have been completed. I think it is likely, in light of the trial conflicts and the things that they have raised, that a June trial date is feasible, although the state would request one sooner. Our thought, I believe, in talking to defense counsel prior to calling the matter and yesterday was that is what we anticipate being the trial date, but that we address the firm trial date when we're back here in February.
I agree, Your Honor.
I don't disagree with that, but the powers that be want at least a trial date that can be subject to change with a motion. So I'll set June 10th as a trial date with July 10th as the last day currently.
Judge, I know I'm not available that particular day. If we can set June 12th, if that's a weekday. I just know the 10th is a day I'm not in the office.
All right, June 12th.
I apologize.
And then a Friday in February.
What was the last date?
July 10th. That's a work day.
February 8th.
February 8th, Ms. Stevens.
Judge, that is fine with the state. I know the victims have been notified on the non-capital counts. If there are any conflicts, I'll let the court know immediately of those folks that may want to attend and address the court.
Mr. Alcantara, Ms. Sparks, February 8th.
That's fine, Your Honor.
Should we do it at 1:30? I'm not available at 1:30. I'm available the entire morning or at 3 o'clock and after.
Well, what's the likelihood of sentencing actually going on February 8th?
I think it's very likely. I don't see a reason why we wouldn't be moving to sentencing on that date in those cause numbers.
I agree, Your Honor.
So if we can do even late morning, I don't know what your calendar looks like that
Well, and
date.
you know better than I know how many folks may come to speak, or whether it will not be a very loquacious event.
I believe in the counts we addressed today, it's unlikely. And if there were comments, they would be brief. It would be the counts that were pled to before, and I anticipate at least one person attending on that date. But I don't anticipate an extraordinarily lengthy hearing. I think 1 hour would be sufficient.
11.
To be on the safe side, Your Honor, let's make it for an hour and a half.
All right, we'll set it for 10:30 on the February 8th date.
10:30.
Yes. Anything else, Ms. Stevens?
Not that I can think of, Judge. Thank you.
Mr. Alcantara?
Nothing I'm aware of.
Ms. Sparks?
No, Your Honor, thank you.
Mr. Crane has something to add.
Mr. Crane?
Okay. Let the record show that Mr. Crane is a sovereign man born in the States of the Union and is not a statutory person bound by the laws of the sub-franchise called Arizona, nor is Mr. Crane bound by any of the laws or statutes created by the franchise called the United States, located in the District of Columbia. While Mr. Crane truly does not understand the nature of these proceedings, he is aware that the Superior Court of Arizona is engaging in the practice of admiralty law, also known as statutory jurisdiction, and denying or hiding that fact or not voluntarily admitting that information. Does anyone in the courtroom disagree with what Mr. Crane has just said? Mr. Crane will then ask the state, does the state have a maritime contract that involves Mr. Crane's name and private property?
Your Honor, as I previously advised, I will not respond to the defendant's questions.
Your silence stands as consent. Number 4, does the state have a damaged party? Your silence stands as consent. That it does not have a damaged party. Okay. Let it show that while Mr. Crane is willing to accept the blame or the claim for these crimes, that he indeed accept the blame or claim that he indeed commit all of these commercial crimes and statutes that he is being charged with. Mr. Crane is here strictly under threat, duress, and is here by special visitation only. Mr. Crane refuses to grant the Superior Court jurisdiction over him or his property and does not consent to these proceedings. Mr. Crane is under the basic understanding that the court only wants to charge some bogus bond to his federal account, and that the court has neglected to inform him that the birth certificate is that bond. It has come to Mr. Crane's attention that the state prosecutor is claiming that they represent the beneficiary, the state, when the state is really supposed to be the trustee. Mr. Crane is the beneficiary of the trust or birth certificate bond, also known as the strawman trust account, not the state, and everything including crimes and taxes is already prepaid through that birth certificate bond. Only the beneficiary, Mr. Crane, can be the plaintiff, while the state is the trustee and can only be the defendant. If you disagree, please give your response now and in a way that I may understand. Your silence stands as consent. Furthermore, Mr. Crane does not consent to these proceedings and again hereby fires his counsel and reserves his right to the UCC 1-308.